Willette, Director General, Academic Outreach and Stakeholder Engagement. And with the Department of Justice, we have Heather Watts, Deputy Assistant Deputy Minister, Mark Scrivens, Senior Counsel, and Corinne Bolduc, Counsel. I thank you all for being here at such short notice. I now invite Public Safety Canada to make an opening statement of up to 5 minutes. Please go ahead.
Thank you, Mr. Chair. Comme vous le savez, le Canada et les alliés.
As you may know, Canada and its allies face numerous geopolitical challenges that threaten to destabilize democratic nations and the global economy every day. The strength of Canada's national security and public safety is being tested. Notably, threats from China, Russia, and Iran continue to threaten our national security and social cohesion. And what has captured the attention of many Canadians, rightly so, is the insidious threat of foreign interference. Interference remains a critical threat to our national security.
Malign activities undertaken by foreign states or those acting on their behalf to advance their own strategic goals to the detriment of Canada's national interest and that of our allies. Foreign interference targets the integrity of our political system, democratic institutions, social cohesion, academic freedom, economy, and long-term prosperity. The threat of foreign interference is not new, but it has increased in recent years as the world becomes more competitive, interconnected, and digital. The Government of Canada is best served when engaging with those directly affected by national security threats on potential solutions. For this reason, we consulted with a diverse group of Canadian stakeholders and partners on potential updates to modernize our counter-foreign interference toolkit in a way that balances various important considerations such as privacy and charter-protected rights and freedoms. On May 6, 2024, the Government of Canada introduced an Act respecting countering foreign interference, also known as Bill C-70, that reflects the valuable input received through the consultations from stakeholders across Canada. The changing global threat landscape and the way in which foreign interference materializes necessitated a modernization of Canada's toolkit for countering foreign interference in all its forms. And while others will speak to the various amendments to the CSIS Act, to the Security of Information Act, and the Criminal Code, aimed at better detecting and disrupting this strategic threat, I would like to highlight Part 4 of the bill for you, the Foreign Influence, Transparency, and Accountability Act. As mentioned, foreign interference takes many forms, but malign foreign influence, a subset of FI, remains particularly difficult to detect and to counter. Some governments and their proxies may leverage individuals or entities to undertake non-transparent influence activities that are intended to shape Canadian policy outcomes or public opinion, deliberately obfuscating the foreign ties. And the intent of the FITA, the Foreign Influence, Transparency and Accountability Act, is to promote openness and transparency around ties to foreign states. And in doing so, to deter and introduce robust consequences for those who seek to exert influence in non-transparent ways. Foreign influence transparency registries are increasingly considered an international best practice. We've engaged with our closest allies and like-minded partners to learn from their experiences in designing our own registry. There are three criteria that, when taken together, would trigger the requirement to register under the FITA. First, an individual or an entity that enters into an arrangement with a foreign principal, where the individual or the entity acts at the direction or in association with a foreign principal to engage in foreign influence activities. Second, when that person or the entity undertakes any of the following foreign influence activities: communication with a public office holder, communication or dissemination of information to the public, disbursement of money or things of value. And thirdly, the activities undertaken in relation to a political or government process. So I want to be clear that it's not the foreign principals that would be required to register. Instead, those those individuals or entities acting at the direction of or in association with those foreign principals would have the registration obligation. And there's no registration obligation imposed on anyone who is the subject of this influence activity either. So before passing to my colleague, I would just note that the registry was designed to be country agnostic, and it's a tool to protect, not persecute, communities from diverse ethnic and cultural backgrounds in Canada. So with that, I look forward to your questions. Thank you.
Thank you. We go now to, we invite CSIS to make an opening statement of up to 5 minutes as well. Go ahead, please.
Good morning, and thank you for the opportunity to be here in support of this important study. Since its creation 40 years ago, CSIS has had to adapt to major changes in the threat landscape to protect Canada and Canadians. From our inception at the height of the Cold War to today's era of global cyber-enabled threats, CSIS has had to continuously evolve its operations. Although foreign interference is not new, the complexity of the modern threat, fueled by technology, highlights the need for appropriate tools and authorities. Les lacunes dans les pouvoirs du SECU.
The problems with the law continue to arrive with the changing technology and the capacity to detect foreign interference, to make inquiries, and to intervene rapidly to protect the interests of Canada. The draft bill proposes some modifications that are very precise to improve operational measures that we can use to fight against foreign interference and meet these three objectives.
Interference extend well beyond the federal government. They include Canada's diverse communities, democratic processes at all levels of government, Canada's rich research system, our private sector, which drives the innovation economy, and the critical infrastructure upon which we rely. Amendments would authorize CSIS to equip national security partners outside the federal government. We have learned from Canadians, especially other levels of government, businesses, and diaspora and minority communities, that they would like more information about the threats they face so that they can build resilience against them. Deuxièmement, les modifications visent à faire en
Second, amendments seek to ensure CSIS can operate successfully in a digital world. CSIS has adapted to and embraced technology throughout its history, but the pace of technological development today is creating blind spots and vulnerabilities that foreign state adversaries and violent extremists are exploiting every single day. Finally, amendments that would enable CSIS to keep pace with emerging and rapidly evolving threats.
Address 5 areas of the CSIS Act. Amendments to current disclosure authorities would authorize information sharing outside the federal government to build resiliency to national security threats. New judicial authorizations are proposed, tailored to the requirements of modern digital investigations. To better leverage data in investigations, amendments are proposed to CSIS's existing data authorities. A tactical amendment to CSIS's foreign intelligence collection mandate to account for the borderless nature of data would better equip CSIS to collect on the intentions and capabilities of foreign states. And finally, review of the CSIS Act by Parliament every 5 years would ensure that CSIS can continue to adapt to emerging threats and changing technology. All of the proposed amendments were designed with strong safeguards in mind. We heard the importance of this from Canadians during our consultations. Par ailleurs, le SECU est toujours tenu de rendre.
As well, CSIS remains accountable to the Minister of Public Safety, who can issue specific direction on any aspect of CSIS's activities. The Intelligence Commissioner will also continue to review and approve a certain of our activities. In addition, all CSIS activities can be subject to review by the National Security and Intelligence Review Agency or the National Security and Intelligence Committee of Parliamentarians.
Review and oversight, including the vital role of the federal court, the legislation would ensure that all CSIS activities to protect Canada and Canadians comply with the Charter of Rights and Freedoms. With that, I welcome the opportunity to discuss any aspect of the proposed amendments to the CSIS Act. Thank you.
Thank you. We go now to Justice Canada. Please, remarks up to 5 minutes, please.
Good morning. Thank you very much, Chair. I'm here to speak to the Justice Canada proposals that you'll find in Bill C-70, in particular those that amend the Security of Information Act, the Criminal Code, and the Canada Evidence Act. The Security of Information Act, or the SOIA as I'll call it, is the primary legislation dealing with foreign interference. Part 2 of Bill C-70 creates 3 new offenses in the SOIA. The first new offense is a general foreign interference offense. This would make it an offense to do any surreptitious or deceptive act for a foreign entity knowing that it would cause harm to Canadian interests. The second offense is the commission of an indictable offense for a foreign entity. This offense would apply when someone commits an indictable offense for a foreign entity. It could be any indictable offense, for example, extortion or bribery. The third new proposed offense is an interference with democratic processes offense. The bill creates a new offense of committing a surreptitious or deceptive act at the direction of, in association with, or in association with a foreign entity to influence a political process or educational governance in Canada. This offense would apply to all levels of government, territorial, provincial, Indigenous, municipal, and would apply to the nomination processes of political parties. This offense would apply at all times, including outside of the formal election period. Secondly, the bill also amends some of the existing offenses that we already have in the SOIA. Section 20 already deals with threats or violence in relation to a foreign entity. Bill C-70 makes it easier to prove this offense by removing the necessity for prosecutors to prove that the offense was committed for the purposes of aiding a foreign entity or was likely to harm Canada. This is a significant modification to Section 20 that would aid in the investigation and prosecution of persons involved in transnational repression, because the intimidation of critics of foreign regimes don't always engage the interests of the Canadian state in a direct way. There's also a proposed amendment to Section 22 of the SOIA, which deals with preparatory acts. The bill increases the maximum penalty for the commission of a preparatory act from 2 years to 5 years and expands the application of that offense to most of the offenses in the SOIA, including the new ones proposed in this bill. For all of the SOIA offenses, including the new ones, there will be a requirement to obtain Attorney General consent before commencing a prosecution. Finally, Bill C-70 also contains a proposed amendment to the definition of special operational information in the SOIA to address the inappropriate sharing of military technology and knowledge. Turning now to the Criminal Code. The Criminal Code currently contains an offense of sabotage that has not been revised since 1951. The amendments in Bill C-70 will modernize this offense. The bill creates a new sabotage offense focused on conduct directed at essential infrastructure and contains a list of what constitutes essential infrastructure for this purpose, including transportation, energy, health, and communications infrastructure, among other categories. The current sabotage offense already provides for exemptions from criminal liability for work stoppages related to labor action or safety concerns. The proposed new offense also recognizes, for greater certainty, the right to advocacy, protest, and dissent. Finally, the bill adds a new companion offense to criminalize making, possessing, selling, or distributing a device to commit the offense of sabotage. The maximum penalty for these 3 sabotage offenses is 10 years. As with the new offenses in the SOIA, the bill adds an additional safeguard by requiring Attorney General consent before a prosecution for the offense of sabotage can be commenced. Turning now to the amendments to the Canada Evidence Act and the Criminal Code in Bill C-70. Currently, the Canada Evidence Act provides a regime that protects sensitive information from disclosure in court proceedings, but generally does not allow the courts to consider that information when deciding the matter before them. Il existe cependant certains régimes autonomes.
However, there are some standalone regimes that allow for the protection and use of sensitive information in administrative proceedings. The judge can take the sensitive information into account when making their decision.
Judicial review, for example, in connection with charities registration and revocations, terrorist listing entities, the Passenger Protect Program, and some passport revocations and refusals. Le projet de loi abroge ces régimes autonomes.
The bill repeals these existing standalone regimes and establishes a uniform process, a secure administrative review procedure for federal administrative proceedings applicable to federal court or appeal or judicial reviews and appeals.
Information that's part of the record. Finally, with regard to criminal proceedings, the bill makes two specific changes involving interlocutory appeals and sealing orders to improve the efficiency and limit delays in the criminal process. Thank you for having us, and I'm happy to take any questions.
Thank you all for your remarks. We'll start our questioning with Mr. Cooper for 6 minutes, please.
Thank you very much, Mr. Chair. I will direct my questions to the public safety officials. How long will it take to implement the Foreign Influence Registry upon Bill C-70 receiving royal assent?
So thank you, Chair, for that question. It's something that is currently before Parliament, and we're going to see where it goes before Parliament. It is going to be a priority for us to set up the office based on the legislation if and when it is adopted to Parliament. We do recognize that there's significant interest in making sure that it is up and running before the next federal election. It is going to be a priority for us to set it up. There are numerous pieces of work that need to be done in terms of bringing in regulation to support implementation of the Act that will need to be done before we can actually bring it into force. It'll be up to the Governor and Council to determine when that coming into force is.
Well, thank you for that. Through you, Mr. Chair, there is regulation that needs to be set out, as well as setting up the commissioner who's going to oversee the registry. And so would it be fair to say it would take a number of months? Because my understanding, at least from the technical briefing, was that it may in fact take up to a year. Am I correct?
It could take up into a year. Not to get too much into the weeds in terms of bringing in regulations. There's a process for regulation, as the chair is aware. There's also a need in the legislation. The Commissioner for Transparency would be obligated to publish a registry to make known individuals who have registered. There is going to be a need to stand up the system so that people can register and that the Commissioner can then publish that registry online to make that information available. And so during the technical briefing, we did indicate that a year is what we're working towards and is the goal that we will attempt to meet.
Well, thank you very much for that. And there's clearly a lot of work to be done. And when I look at the calendar, it's May 30th, and there's only a few more weeks left before the House rises for the summer. And so looking at the next election, that's October of 2025. That's about a year away right now, having regard for the fact that we only have a few sitting weeks. And so this is just, this underscores a real concern that I have that this will not be in place in time for the next election. And it's as a result of a government that has dragged its feet, dragged kicking and screaming to finally introduce a foreign influence registry, despite calls for years by security experts, by diaspora communities, by conservatives. Indeed, it is, I would submit, not a coincidence that this legislation was introduced the day after the first sitting day after the damning report of Madam Justice Hogue, a damning report, an indictment of the government, an indictment of the Prime Minister. This is nothing more than an attempt by this government to use this bill for political cover in the face of conclusions that demonstrate that that we have a Prime Minister who turned a blind eye to foreign interference. And I have to say, the delay is unacceptable because consultations for a foreign influence registry ended 1 year ago. And therefore, had the government introduced legislation a year ago, we would have a foreign influence registry in place well ahead of the next election. But because these Liberals have delayed and failed to act, here we are with the very real possibility that we won't have a foreign influence registry in place. And if there is one in place, it will be right at the time that the election is called, which raises questions about its effectiveness during the campaign period. And given the timeline that we have, it is why Conservatives believe that it is absolutely imperative that we move this legislation forward quickly. It's why my colleague, Mr. Chong, the member for Wellington Halton Hills, introduced a motion yesterday in the House of Commons to see that this bill would pass through all legislative stages in the House by June the 12th. But incredibly, yesterday in the House, the government's coalition partner, the NDP, blocked Mr. Chong's motion. And so here we have the coalition partner of the Liberals who've dragged their feet for years, who are now obstructing moving this bill through Parliament. And I can't help wonder why that is. It certainly demonstrates that Jagmeet Singh, once again, is an unserious leader, having regard for the fact that he doesn't see the need to move this along. And it raises questions about whether the NDP is doing the government's dirty work.
Thank you, Mr. Cooper. We're going now to Ms. Zaid. Gentlemen?
Thank you, Chair.
Gentlemen, settle down, please. Ms. Zaid, please, go ahead. 6 minutes.
Thank you, Chair. Thank you to all the witnesses for appearing before the committee on this important legislation. My first question is for the CSIS department. Bill C-70 proposes amendments to the CSIS Act that would, among many other things, expand its warrant capabilities. So I have some concerns about this expansion of authority, given concerns regularly raised by the courts about CSIS not abiding by its duty of candor in warrant applications. So could you please outline reforms you have taken around your duty of candor to the courts and building trust with minority communities who have in the past felt targeted by CSIS and are the very communities often targeted by the foreign interference we are trying to guard against in this legislation?
Thank you for the question. The service has had a significant amount of effort in place to address previous concerns about significant gaps in our duty of candor. It is a duty that we take very seriously. The federal court and review bodies have pointed to concerns, and we have taken significant measures, including training, the development of a professional affiant corps, embedding legal counsel in various operational activities in order to really understand and fully meet the duty of candor to the service. We recognize that this is a failing that's unacceptable and that creates gaps in trust for Canadians. I'm going to pass it to my colleague Renee to speak to the second part of your question, if that's okay. Thank you.
Thank you for the question, Chair. I think the first thing we want to point out is that since 2019, we've created a program that significantly expands how the service does outreach and engagement with communities across the country, recognizing that it's our responsibility and our duty to protect all Canadians. We have deployed significant resources, time and effort in rebuilding trust where trust had been lost or fractured, in acknowledging and atoning for some of the mistakes that we've made in the past with communities. And we have made some significant progress, I think, in building that trust. It takes time, it takes patience, of course, it takes humility, and we have brought all of that to bear in our efforts to build these relationships. And we continue to have them in daily conversations, weekly meetings, face-to-face, over the phone, emails, everything, to make sure that we are available to communities when they need to talk to somebody about the service or about threats that they're feeling, because we do recognize that, especially in the context of foreign interference, that often the first victims of that activity are our communities themselves, diaspora communities, marginalized communities, and it's really important to us to make sure that we are, again, protecting the interests of all Canadians, not just.
Thank you. This legislation also enhances the CSIS capability to collect and use data sets. So obviously the protection of personal information, data management, and abiding by privacy protections is going to be very important here. So could you please outline what steps are being taken to address privacy concerns and to ensure data is properly obtained and is reliable before it is used?
Thank you for the question. The dataset authority in the CSIS Act is an extremely complex regime that thoroughly embeds privacy protection at every step. It requires ministerial accountability and oversight. The collection and retention and use of data is undertaken through strict controls, including, for example, designated officials are only able to handle data in the evaluation period. It must be segregated from other CSIS holdings. There are a number of different steps in the approval process. The retention of Canadian data must go to the federal court for approval. So the scheme itself is heavily embedded with the appropriate safeguards for the privacy rights of Canadians, recognizing that that is the essential need for data, is to understand dynamics in our threat environment while at the same time protecting the privacy of Canadians. The amendments that are proposed in the bill make some significant changes in terms of the process, but they do nothing to change the safeguards. In fact, in some ways, they enhance safeguards. For example, currently, the service, when it seeks to retain a data set that contains both foreign and Canadian data, it goes through two tracks. And we're proposing an amendment that would see all data in mixed circumstances like that be applied to at the Canadian standard, which would mean it goes to the federal court. So none of the safeguards in the existing regime will change. The role of the federal court and the intelligence commissioner remain, as well as ministerial approval for classes of Canadian data sets and designations. So it's a significant improvement in process to enable us to better make use of data, but no change with regard to the safeguards the scheme already has in place.
Thank you. My next question is for the Department of Public Safety. Could you outline the concerns you have heard from the diaspora communities in regards to foreign interference, and what steps are you taking to ensure they are not inadvertently victimized or stigmatized by the efforts to combat foreign interference?
Thank you. We've received significant feedback from different communities across Canada. I'm not going to go into the specifics, not for attribution, obviously, and has been summarized in the What We Heard report. But very clearly, clear concerns around foreign repression, transnational repression, and more protections needed for these communities. We've heard also that they may have some concerns around being stigmatized, and it's pretty clear that the way the legislation was designed was to be country agnostic and making sure that it offers the right protections but does not identify or stigmatize a community. We also heard that any effort to counter foreign interference needs to be accompanied by clear messages around anti-racism, and we've been working very closely with Heritage Canada to make sure that we align with with their efforts for countering racism in Canada.
Thank you. I have to cut you off there now. Thank you. On y va maintenant, Monsieur Villemur.
Now, Mr. Villemur. 6 minutes. Thank you very much, Chair. Thank you to the witnesses. I'm going to start with the public safety. I'd like to know, in building the register, of course, there have been registries in other countries. There are a number of models, but what I was interested in, and I thought it was in the bill, but I don't see it, it's having a double registrations. So the foreign group must register and see and the local, and so that we can identify who they are. Why not have a double registration in the registry? Thank you very much for your question. The registry has been proposed to emphasize the individual who will be will have an agreement with a foreign government, and we have identify certain behaviors, for example, providing funding or money, and also communication activities that are aimed at not a specific person or a group, but public, the general public. So we are stressing the individual who has an agreement with a foreign government. On the other hand, we are also trying to provide the commissioner and the officials with the possibility of groups that might not register or in order to make complaints or and also to receive information, providing information on situations where there is not really a person in the registry. And so this will stress, like other measures, on the individual. And what if the person doesn't register? So let's say there's someone who's working secretly, and there could be a complaint or someone who reports them. But if the commissioner is working on the activity, but there is no person registered, so and would that not be a reason to investigate? Thank you very much, Chair. I would say that one aspect of the bill and the work of the Commission would be awareness raising, being awareness of the individual's obligations, for example. Let's say that there was somebody who was in a public position who might be approached by an individual, and the public official might have some suspicions, so the person will see if they're on the registry, and see the person is not on the registry. And if the commissioner has done their information for their work for providing information, and that is a way that the commissioner could act to identify their not. Is there a registration for the public? There's a public. There is an obligation for individuals, and if we talk about subnational institutions as well, this is a law that is aimed at individuals who might be working for foreign entities. So it's the as I may be wrong, but in the bill, if there is a foreign actor with influence on public policies, they are required to register. But the Winnipeg Laboratory, where there are students or Chinese government agents in the government laboratory, I think this was an act of industrial espionage, and so there was interference in our in our intellectual property here is, would the registry could have dealt with this kind of a situation, or would it be kind of fall between the cracks? The issue with the registry is transparency for public affairs and foreign agents or foreign actors, and could be under the law on the security of information. So the registry would not necessarily no. The registry is aimed at increasing transparency or any effort to influence public opinion. Thank you.
Mr. McGregor, 6 minutes, please.
Thank you, Chair. Before I begin with my questions, I need to intervene and address the points that were made by Mr. Cooper. First of all, there are not many public office holders who know intimately the noxious nature of foreign interference than Jagmeet Singh. It has affected him personally. It has affected his family. It has affected where and when he can go in public. So to make those kind of allegations at this committee, frankly, are incredibly disrespectful. And I think the committee should take note of that. The other part I want to make note of, Mr. Chair, is that I had conversations with Mr. Chong yesterday in the House of Commons. I thought they were conversations that were quite respectful. The NDP was quite prepared to program this bill through various committee stages. And just because we didn't go as far as the Conservatives wanted to, they decided to make those kinds of allegations. So I think that kind of misinformation is really unfortunate. It's unbecoming of the seriousness of the topics that we're discussing here. And I think that needs to be cleared up and put on the record. With that, Mr. Chair, I want to turn to a few questions. I guess this is more to CSIS. I mean, having a public registry is one thing, but we as members of this committee can only surmise that there are an incredible number of clandestine operations where a public registry would not affect those actors. They're not going to take the time to register themselves and comply with the provisions of Part 4 of this bill. I know you are limited in what you can say at this public hearing of the committee, but this is a question I posed to the minister yesterday during debate. Can you at least talk about, how successful we've been with existing laws in laying charges and getting convictions? Anything that you can help inform this committee as we look at this legislation before us?
As you know, the service, thank you for the question, Chair. As you know, the service is not a law enforcement agency and is not, ultimately responsible for the laying of charges or the prosecution thereafter. I can say that the foreign interference space is indeed a very particularly complex one. Much of the activity, as we've discussed in numerous fora recently, is extremely gray. It is not always directly linked back to a hostile actor. There's often several degrees of separation. There can be all sorts of legitimate activity, and a fragment of that could be illegitimate. So the detection, the investigation, and the ultimate downstream prosecution in these cases can be complex. And part of that goes to the package of amendments before you. Part of it goes to the offenses, which I'll let my justice colleagues speak to, and part of it goes to the challenge of using highly sensitive intelligence and disclosing it to the RCMP in such a way that they can use it to launch an independent and parallel investigation, and then protecting that sensitive information when it comes to a court proceeding. And some of the measures we're talking about today will make incremental movements to improve that scenario. So maybe I'll pass it to my justice colleagues who could pick up the back end of that question.
Sure, thanks, Sarah. I think as my colleagues have said, The idea in C70 is to really build the toolkit for how the government can respond to foreign interference. So the work that public safety has done to establish a registry is one piece, and obviously the proposed offenses that we have in the Security of Information Act are another part of that. So I think some of the activities that we've seen reported in the media, some of that may already be conduct that is criminal activity, but some of it may not. And so one of the things that Bill C70 is trying to do is to sort of bridge that gap a little bit. So in particular, I would point you to the new proposed offense that would be in 20.3 of the SOIA, which is conducting an omission or an offense for a foreign entity. So the underlying conduct there doesn't itself already have to have been a criminal offense. So there's a distinction between two of the offenses we're proposing, and so part of what we seek to do is to make things that are tied to foreign entities, that are a threat to Canada, that harm communities, an offense in a way that it's not currently captured by the law.
Thank you. I also, maybe this is to public safety, in Part 4, under definitions, when you look at the definition of arrangement, it's talking about being in association with a foreign principal, and it can cover just communicating with a public office holder. I know this act is country agnostic, but certainly in the public perception, some countries, there's a hierarchy in terms of the Canadian public's perception of certain countries. I guess there's a concern in the interpretation of the word like being in association. Can you comment a little bit more on how you interpret that?
So thank you, Chair, for the question. And the definition of arrangement is, as you point out, it's general in the sense that it would not require, and it would be the interpretation of all this would be up to a commissioner, obviously, so I'll preface that by saying that, and eventually to a judge of the federal court if a decision were to be challenged. But an arrangement wouldn't need to be a written contract. It wouldn't necessarily need to be spelled out on paper. It can be a verbal understanding. Ultimately, it would be up to the commissioner, based on the facts available to them, to determine whether there was an understanding, an arrangement, an agreement to conduct these influence activities. And so it's purposely drafted in a way to not limit it to just that one I have a contract that says I will pay you X to do Y.
Thank you. We'll start our second round now. We'll go right now to Mr. Caputo. 5 minutes, please.
Thank you very much, Chair, and I'm very grateful to have the expertise around the table that we have, and I thank all the witnesses for being here. I generally don't put my questions to one person in particular because I know that there's a lot of overlapping expertise here. So please, among you, just feel free to chime in if you feel like you have a good answer to the question. My first line of inquiry looks at what we've colloquially called the Foreign Influence Registry. When it comes to that, what would be the minimum amount of time that it would take to set something like this up, and perhaps even just what would be estimated? I think 1 year was kind of thrown around, but I'd like to get to a bit more of a solid answer, if I could, please.
Thank you, Chair, for that question. A year is what we are estimating currently it would take to set up the registry, and that's taking into account, just to get into some level of detail, regulations that are required to launch the operation of the regime. There are some pieces of regulation that are necessary to do that. There's for example, the information that must be provided to the commissioner by a registrant, and then the information the commissioner shall make available on a registry. So just to give 2 examples, there are others. That requires building an IT solution to do that. It requires developing investigation capabilities. It also requires hiring, the commissioner was referenced earlier, and standing up the physical or organizational structure. And so it is a significant amount of work, and therefore a year is what we are estimating would be required to start the operation of the registry.
So if this bill does not receive royal assent, let's say we are looking at the fall, and the election must occur by a date in October of 2025, move back a week, I might note, so that the leader of the NDP can get his pension.
Point of order.
McGregor on a point of
I've
order.
got great respect for Mr. Caputo, but if he wants to have a proper line of questioning without interruptions, he can probably just stay on the topic at hand.
Thank you.
When it comes to the timing of the election, and we do have issues with the timing of the election regardless of what mothers at this table may agree with or not agree with, we're looking at an October 2025 election. If this bill does not receive royal assent before we break, or at least we substantially have done the work, and we are into the fall, we could then be not even in a place to have this in place and functioning prior to the next election if it were to occur in the fall of 2025. Is that accurate?
Well, we're estimating about a year to put in place the registry and the commissioner in the office around it. We can look at how timelines could be accelerated. What I want to mention is that the SOIA new offenses and the amendments would come into force 60 days after royal assent, and that would be well in place for that timeline.
I'm sorry, could you repeat that last part, please?
I said the SOIA amendments and criminal code amendments will be in place 60 days after royal assent.
So the amendments will be in place, but I think what concerns people, me anyways, and the people around this table is there's no use in having a registry if what it is aimed to combat really can't be combated because we ran out of runway, which really does speak to Mr. Cooper's earlier points. I mean, we had Bill C-282 by a former colleague of this House, Mr. MP Kenny Chu at the time, who I think fairly clearly there was electoral interference that may have cost him his seat. And we could be running into that very thing, and that's of concern to me. Now, I'm going to ask a few other questions about the appointment of the Foreign Intelligence and Transparency Commissioner. That the appointment occurs through an order in council, is that correct?
That's right.
Okay. And at this point, there has to be consultation with the House and the Senate. Is that accurate?
That is correct.
Okay. Now, other officials, and I don't want to draw a parallel between the officials, but other such officials, sometimes there has to be some sort of approval by Parliament and the Senate as opposed to simple consultation, because consultation can be ignored. Would it strengthen the independence of the Foreign Influence and Transparency Commissioner if there was a requirement in the legislation to have formal approval by the House and the Senate?
That's your time, but you witnesses may answer.
Amendments to the bill will be up to Parliament. I think the registry or the legislation proposes a number of elements that would make the commissioner independent in their decisions to pursue action, and those are built into the legislation.
Thank you. We go now to Mr. Biddle, please. 5 minutes.
Thank you so much, Mr. Chair. My first questions will be to CSIS. What operational gaps does this legislation look to fill?
Thank you for the question. Excuse me. Really quite a few. There's 4 aspects of the bill of the current CSIS Act that are significantly impacted by the proposed amendments. Operationally, for the service, one of the biggest activities that we're coming up against limits on is the sharing of information and the equipping of national security partners and stakeholders outside the federal government. Across Canada every day, CSIS officers are engaging with communities, with businesses, with provincial, municipal, territorial governments, and they're encountering significant limits in how they can share information to meaningfully build resilience. And this bill would address that gap with some proposed amendments. And I think the second one I would highlight relates to judicial authorizations. Currently, the service has a single warrant authority that is tailored to highly intrusive techniques and very much appropriately built for that purpose with high safeguards and significant requirements. But today, in the digital world we operate in, a vast number of fairly routine and basic investigative activities. Here I would point to, for example, identifying the individual behind an online disinformation campaign believed to be driven by a foreign state. The subscriber, the identifying information of an account holder online is something we need to go to the federal court for a warrant for. And that warrant requires the same elements that intercepting phone calls does. So you can see that it's not really appropriately tailored to the kind of data that we would be getting. And so one of the proposals today in the bill includes a production order. There are a number of others. There are two others in that suite that would allow for much more tactical and regular approaches to the federal court earlier in investigations, and we anticipate that could yield significant operational value and much more nimble investigative posture.
Thank you. In designing the legislation, what lessons, if any, did you take from the enabling legislation that exists in other Five Eyes countries?
For CSIS, we certainly always consider our allies, especially the Five Eyes, in their legislative schemes. Obviously, they're all very different. The UK has done some important work on data that has informed elements of our data authorities. They've just recently amended their data authorities after about a similar amount of time, recognizing the incredibly dynamic pace at which the data and digital world is advancing. We always understand the authorities of our partners when it comes to, for example, engaging with stakeholders and looking at disclosure of information. That question may also want to go to others at the table.
If public safety could...
On the creation of the registry, we've consulted very closely with the US, Australia, and the UK. The UK just introduced the new registry, and we've learned a lot from them. Also, the UK and Australia have significantly revamped their national security legislation in recent years. The UK most recently, and we've taken a close look, and we had good collaboration from them on shaping our legislative package.
Thank you so much. Stick with public safety. Did you consult with Indigenous, provincial, and territorial governments? And if so, what feedback did you receive during the consultation process?
We have engaged with national NIOs and also right holders across Canada. We've received overall very positive feedback. Especially the registry, is a tool that they will be using for the conduct of their activities as governments. And so looking to this tool as a very positive step in the right direction. Some concerns were presented by some of the stakeholders around the application and the respect of the rights of these governments, and obviously the bill has been designed in that context to protect and to these rights and to support their operations as a government.
Thank you so much.
Thank you, Mr. Biddle. On y va maintenant, Monsieur Villemure.
Now to Mr. Villemure, 2.5 minutes. Thank you. Thank you very much, Chair. I'm going to ask public safety, my favorite ministry. It's for sure that some of the things are left for regulations, but with regard to the commissioner, and I'd like to know what the kind of profile do you imagine for choosing you must have some kind of a profile of some eventual commissioner. What would be that profile? Thank you very much for the question. Finally, the decision of who will be appointed commissioner will be provided for under the advisory committee, and it'll depend on the profile they find, their competencies. Will they be qualified for the role of commissioner? There's no profile set out by the regulations, but it is a process that I think we're familiar with for state election commissioner. But you said it won't be a plumber or it won't be an electrician. So, without forcing you to give me a response, I'd like to say how broad could this definition be? I mean, there are other commissioners, and I think that this commissioner is a very particular position, and I'm not going to hold you to anything that you say in the future. But what type of person are you looking for? Thank you very much. It's not really up to me to take this decision, but you can look at other commissioners who have similar roles, and that might give you some idea of the type of person would be looking for. But the other commissioners are often judges or ex-judges, and certainly a judge would be an excellent candidate, but this is not the only category of person. There are other types of individuals, and I would like to ask you to maybe broaden the range that you're looking for.
Witnesses may answer quickly.
But 2.5 minutes?
The time is up, but I
Okay.
No, I'm sorry. Maybe I'm confused. I thought you asked a question. No, sorry. I may have zoned out there. I apologize. We go now to we go now to Mr. Mr. McGregor.
Thank you,
2.5
Mr.
minutes.
Chair. Just to public safety, just a very quick technical question on Part 4, the new Section 4, where it's talking about the application of the Act. You mentioned the federal political and governmental processes, provincial and territorial. I was just wondering, like, are municipal and regional governments not mentioned because they're creatures of the province? Like, we can assume they are covered by this. I just want to make sure we're not leaving anything out.
That's correct.
Okay, thank you very much. My next question would be to CSIS, and I know you've already discussed the data set regime. I read the National Security and Intelligence Review Agency's report on the CSIS data set regime, and I think it's safe to say that that report was pretty scathing. There's multiple instances where NSERA is finding that CSIS did not comply with the provisions of the CSIS Act, and it's just littered right throughout their report. Now, I understand, like, we were talking at second reading debate of this bill yesterday about bringing what essentially is an analog law into the digital realm, and I understand that the complexities of data these days warrant an upgrade to the Act. But can you see it from my point of view as a legislator that if CSIS has been unable to comply with an existing statutory framework, why I might have some hesitancy or questions going forward in updating the Act? I guess we're looking for an assurance from CSIS that if we're going to give you these new provisions, that we're not going to see a future NSERA report like this.
Thank you for the question. Certainly, one of the principal objectives of the amendments is to provide a very clear, transparent law when it comes to data sets, to maintain the safeguards that are in place, but also to ensure it can be implemented lawfully and appropriately. And so currently, the complexity of the regime, as you said, and I think I've written that line before, the analog nature of the law when it comes to very complex, messy, unorganized data, it is an extremely challenging space. And so many of the amendments seek to provide clarity, reduce duplication in process, allow for a single, I mentioned already, a single application for a mixed data set, which would take it to the federal court for approval, rather than having to parse data and take two parallel tracks and risk that there's undetected data in one half of that data set, et cetera. So a great deal of the amendments will in fact achieve the objective of ensuring clear and straightforward law that can be carefully adhered to. And absolutely, it is a challenging space. We've seen from our UK partners that they've also dealt with certain challenges in implementing their new law and have already amended it as well. It is novel legislation.
Thank you, Mr. McGregor. We go now to Mr. Jennis. 5 minutes, please.
Thank you, Chair. Winston Churchill apparently once quipped, you can always count on the Americans to do the right thing only after they've tried everything else. And in this case, the Liberal government has definitely tried everything else to avoid action on foreign interference over 9 years. But with C-70, they've finally responded to pressure from the opposition and from the public. Conservatives don't want to let the government get away with sitting on this bill. After 9 years, we've had enough delays. We will push for anti-interference measures to be passed and in place as soon as possible. Now, one important flashpoint for the foreign interference conversation is Hong Kong, because Hong Kong's national security law makes absurd claims of universal jurisdiction, even claiming that if a Canadian in Canada makes statements that are deemed to violate Hong Kong's national security law, they could be charged and even